Good afternoon, everyone, and welcome to our latest Legal Cheek virtual student event in partnership with BPP University Law School. I'm Juliet Griffiths, Head of Student Engagement here at Legal Cheek, and I'm very excited to introduce this afternoon's session, which is part of a series of SQE-themed virtual events that we're running with BPP. Although the SQE has now been in force for a few years, the assessments can still feel like an insurmountable hurdle. Today, we are going to be taking a deep dive into the regime's first stage, SQE1, to give you a taste of what SQE preparation is really like. Following this session, we've also got a dedicated session exploring SQE2 in April, so please do sign up to that on our website if you'd like to get a complete overview of what the SQE is like. Besides this, you can find even more information about the SQE on our SQE FAQs page, which includes answers to the most frequently asked questions that we receive about the SQE, written by BPP's SQE experts. And my colleague will post a link to this in the chat in just a moment. Moving on to this afternoon's event, I'm delighted to introduce BPP's Head of Law, Hilary Chadwick, who will shortly be hosting this workshop and telling us all about SQE1. And I will shortly drop off stage to hand over to Hilary to dive into the taster session. But before I do so, I just want to quickly explain how this afternoon's event will work. For the next hour, we'll be hearing from Hilary about all things SQE1. At around 5 p.m, I'll pop back up on stage and direct everyone to the expo for an hour of virtual networking with the BPP team, which is the perfect opportunity to ask all of your follow-up questions. During the session here on stage, you can ask your questions as we go along in the chat tab, which is located on the right-hand side of your screen. Although it may be best to keep these for the networking because we have got quite a lot going on during this first hour. Besides this, I would also like to direct your attention to the polls tab, where during this first session, we're going to be sharing a series of practice MCQs for you to have a go at. But I will let Hilary introduce these properly as she goes along. Final thing from me, just make sure that you've got your chat set to stage instead of event. And that's just so that we can see your comments and questions as they come through. Without any further ado, I'm going to hand straight over to Hilary.
Thank you very much, Juliet, and a warm welcome to all of you. I've been looking at the chat as we've been going through, as we've been counting down, waiting for this session to start, and I can see that you've come, you're tuning in from very many places, not only in the UK, but across the globe. So a very warm welcome to all of you. So as Juliet said, I'm head of law, but I'm head of law of one of BPP's centres, which is the centre in Waterloo. We call it London South. And there we teach the law conversion course and also our legal apprentices. I've been in higher education for over 25 years now. So I previously taught on the legal practice course, and I now teach on the SQE1 over in our other centre in London, which is at Holborn. So that's a bit by way of background. I was in private practice many years ago, but for the last 25 years, I've been focusing on professional legal education. So it's lovely to be able to present this session to you this afternoon. So what is the aim of this session? Well, it's to give you an idea of how we teach our SQE1 programme. And we teach in a very contextual way, i.e., by which I mean that we teach the law in context, because we know that if you understand the law, you'll be able to apply it to a multiple choice question. And this ability to know and understand the law also feeds into the SQE2. Now, on SQE1, all our workshops are 2 hours in length, and we usually have around about 20 students in each group. What we're going to do today is we're going to be looking at part of a workshop. Obviously, I can't replicate the whole thing because we've only got an hour's session here today. But what we'll be doing is looking at our teaching methodology for the SQE programs alongside the workshop content, and we'll see how it all fits together. So we post all our materials, so all our SQE materials are available through our virtual learning platform. We call it the Hub. At other universities, you may have come across Blackboard or Moodle or something else. But as well as having our materials on the virtual learning platform, we also give students physical workbooks when we teach the SQE, because we know that students like to have the physicality of having a workbook. The other thing to note is that we teach SQE1 at master's level, so it's the equivalent of getting a master's qualification. So that's really important to know. And so therefore, because we teach at master's level, there's a certain amount of a pre-reading before you actually come to the class. Now, as far as this session is concerned, we're going to be doing it in the context of wills and the administration of estates, which is what I've been teaching, and I have been teaching for many years now. But what we do, or what we demonstrate in this session today, is replicated on all the SQE1 modules. So, as I say, there's a certain amount of pre-reading, and when we look on the next slide, we're going to have to give you a bit of a heads up, a bit of a crash course in certain terminology in relation to wills, because we've taken the content of this taster workshop from what would be the second week of teaching in the wills module. So let's have a look at some of the key terms that are going to be essential to you in this taster workshop. If you are familiar with these terms, that's all well and good, but otherwise, it'd be interesting to learn some new terms. So you probably know that in England and Wales, a person can write a will, which is a legally binding document. And that will directs how that person's money and property will be divided after they have died. The person who writes the will is known as the testator. And when the testator dies, the will governs where their property and money goes. And the deceased's money and property and other assets are called their estate. And the people that administer the estate are known as the executors, and they're appointed by the testator to ensure that what they want to do after when the testator dies, they're the people who deal with the estate on behalf of the deceased. The people who are entitled to a share of the deceased estate, I say people, but we've got an interesting point in a minute. But the people who are entitled to a share of the deceased estate are called the beneficiaries, and the grant of probate is the legal authority for an executor to administer the estate of the deceased. Now, the other important point to know about England and Wales is that in this country, in England and Wales, I should say, the testator has freedom to give their estate on death away to whosoever they wish. And this contrasts with some countries where the law will dictate that a certain portion of their estate will be given to particular beneficiaries. So in England and Wales, we have this concept that is called testamentary freedom. Now, in reality, and in most cases, when the testator's will is read, there aren't very many surprises in it. Many testators will leave their estate to close family members, which is what you would expect. But what if they don't? And this is going to be the substantive content of what we're going to be looking at in this session. So on the next slide, this is a slide directly taken from our workshop. And as I say, in each of our SQE1 modules, there are 10 substantive workshops per module. We also have an additional workshop on professional conduct and a revision workshop as well. And in the wills and estates module, we cover two different scenarios. So in the first 5 workshops, we have a scenario relating to Robert and Tara White, and who are the family that we see on the screen now. And in the second half, workshop 6 to 10, we have a different scenario. So, going back to Robert White and his family, we start off getting instructions from Tara because Robert has recently died unexpectedly. Now, Tara does have children from a previous relationship, but they're not going to be relevant to this workshop today, so we don't need to consider them. Robert, however, as you can see on the slide, does have one son, Andrew, from a previous marriage. And we also need to know that Andrew has been living with Tara and Robert for a while, but has recently moved in with his girlfriend just before Robert died. And the other thing of note is that Tara and Andrew do not have a good relationship. Okay, so let's have a look at the next slide where we'll see what Robert's assets are, and let's have a think about this. So, Robert's estate, as we identified earlier, is the property that he has at the date of death. And this includes his half share in the family home, which is worth, his half share is worth £300,000. He also has some personal possessions, which would include items such as a car, jewellery, electronic devices, furniture, etc. And together those have been valued at £30,000. And he also has savings of £185,000. But before the beneficiaries can receive anything, Robert's debts and expenses, which would include the cost of the funeral, need to be deducted from that amount. And so we've estimated that the debts and reasonable expenses in this case are £15,000, and therefore the net estate available for distribution to the beneficiaries is £500,000. But how does that translate to Robert's will? What has he decided to do with his money? So, in this workshop, in workshop 2, if you were studying with us, we'd look at various clauses in the will, but we're just going to give you a highlight of what how Robert has decided to distribute his estate. So if we look on the next slide, we'll see that Robert's will gives £20,000 to his son Andrew, £40,000 to the local cat shelter, and he gives the remaining estate, which is £440,000, to his wife Tara. So, how do you think Andrew would feel about that? I imagine that he'd be very, very disappointed, but he's going to feel a bit cross and a bit angry that there he is in this situation where the vast majority of his father's estate has been left to his second wife, Tara, and also the cat shelter has been given twice as much as the gift to Andrew. So you can imagine Andrew is feeling a bit fed up and annoyed about this. Absolutely, Zainab, he's going to feel really upset, not fit, not good, vexed. Absolutely, Andrew will want more, no doubt. He's going to be upset. He's not going to be happy. Absolutely, you're all on it. So, thank you very much for that. He's going to feel really upset, as Charlene has said, upset, unfair, angry, devastated. You're absolutely right. So Andrew goes and gets some legal advice. So off he goes to a solicitor who gives him some advice. So we have this letter from Andrew that you've got on the screen now, and I'm going to give you a couple of minutes just to have a look through that letter and see what it says. So, as it says, he has been to see a solicitor to get some advice. It says he's been at university, but he's finding it difficult to get a job. He's got low paid work, and he's used all his savings to fund himself through university. He says that he's very disappointed, as we know, about what's happened with his father's will. He's living with his girlfriend, and she's been very supportive. He accepts that he and Tara have not had a good relationship, and he can't believe that this will is really what his father wanted to do. So he says, I have seen a lawyer who told me that if I haven't been properly looked after, I can get the court to give me a share of dad's estate. So, is this correct? Can he go to court to get a share of his father's estate? Well, if we just click on again, we will see that there is some legislation, the Inheritance Provision for Family and Dependents Act of 1975, that does allow him to make a claim. So, whilst the starting point in English law is that the testator has freedom to leave his estate to whomsoever he wishes, as Robert has done, Andrew's lawyer is correct. And this Act of Parliament allows people to challenge an individual's will if they fall within certain categories and fulfill certain criteria. And this forms the topic of what we're going to look at in this session in more detail. So before we do that, let's have a look at BPP's teaching methodology. So, when we were aware that the SQE was coming in, which, as Juliet said, was several years ago now, we spent time developing what we have called the learning cycle. And this is the same process for every module across all our programs now. So, looking at the learning cycle, of which the prepare and apply work come first, this is the work that you do outside the workshop. This is your pre reading that you do before you actually come to class. So, this prepare stage, you are given directed reading that you can either do in the physical workbook, or we have our materials which we call our adapt materials, which are available online. And there's reading, but there may also be recordings available for you to have a look at. Now, the apply stage is when you're set a realistic task by your supervisor in a virtual law firm, such as you might expect to receive as a trainee solicitor or during your qualifying work experience. So, this is looking at the law in a practical context. But for the purposes of today, we've condensed the prepare reading. So, you're only going to have to advise Tara about Andrew's letter. As it said in the actual workshop, we'd go into far more detail. So, as I say, in the material, it's given to you in bite-size pieces, and we're going to we picked out some slides from the adapt material to share with you now. Okay, so the first slide that is taken from the adapt material sets out what the a highlight of what the legislation actually says. So, what we're concerned about when we move on to the next slide is the bit that is highlighted. So, close relatives have no legal right to inherit any fixed proportion of the estate, but they may make an application to the court under this act to vary the content of a will or intestacy, so somebody dies without making a will. And the court has the power to make provision for an applicant if it feels that reasonable financial provision has not been made out of the deceased estate. So let's have a think about it. Let's apply it to Andrew's scenario. Andrew could very well argue that the £20,000 that has been left to him by his father is not reasonable financial provision. And therefore, we can conclude that he can make an application under this Act, the Inheritance Provision for Family and Dependents Act. But does he meet the categories of people that can actually make an application? And when we look on the next slide at section 1, subsection 1 of the Inheritance Provision for Family and Dependents Act, we can see that this lists the categories of applicants. So the first category that we've highlighted for you is a spouse or civil partner of the deceased, or a former spouse or civil partner who has not remarried or formed a subsequent civil partnership. So, as you can see from reading this, Tara, who is Robert's spouse, would be able to make a claim under this act, notwithstanding that she has received an inheritance under the will. But because she, to be honest, it's fairly academic because she is the main beneficiary anyway. So if we look at the next slide, we'll see the next category of people that can inherit under the will. And this is an interesting one. This is a person other than a spouse or civil partner who has cohabited with the deceased as if they were spouses or civil partners for 2 years immediately prior to the date of death. Okay, so we don't have anybody who that we know of in the fact pattern that would meet this criteria, but it's an important category of people to bring your attention to. So moving on to the next category, that says a child of the deceased. Okay, so let's stop for a minute there. A child of the deceased can make an application under this act. And also, as it says in brackets, adopted children are recognised as the children of the adopters for all legal purposes. So, adopted children would fit into this category. So, as we see, one of the categories of persons able to make a claim under this act is a child of the deceased. Andrew is a child of the deceased and therefore is a person within the category of somebody who is able to make a claim. So effectively the advice that Andrew has got from his solicitor is correct. The last category that I want to look at, it's a kind of catch-all category at the end. It says any other person who was maintained wholly or partly by the deceased immediately before their death. So this is any person who receives some kind of maintenance from the deceased. For example, if the deceased allowed them to live in their home or gave them money or financial support for their reasonable needs, then they can make a claim, even if they don't qualify under any of the other categories. So, for example, it could be somebody who had been cohabiting but hadn't cohabited for 2 years, as we saw in a previous category, because anybody who's lived as husband or wife or as a civil partner for 2 years immediately prior to the death has a right to make a claim. Okay, so we can conclude from having a look at the Act, Section 1 of the Act, that Andrew is within the category of persons who can make a claim under this Act. But there is a time limit. So as we see on the next slide in section 4, it says that an application under the Inheritance Act cannot be made more than 6 months after the date of the grant of probate was made. As it says in brackets, although an application can be made before the grant is issued. So you've got to be on it. So, we've established that Andrew falls within one of the prescribed categories. we need to know, is he within the time limit? Before we move on to that, why do you think we have a time limit? Why do you think that time limit is important? Who needs to have that time limit? Why is it going to be important? I'll give you a couple of minutes to type in your answers, because I know there's. So why is that time limit important? Who might need to know? Absolutely. So, I haven't got my glasses on, but I can see, for the time for the executors to distribute, absolutely. You want to get those funds out, prevent floodgates. Yeah, absolutely. These are all really, really good examples. They want to make the process easier. The executors need to be able to know that they are able to distribute the estate, and the beneficiaries need to know that there aren't any other beneficiaries lurking in the background. Now, what I can tell you, because as I said, this is workshop 2, we're still very early on in the case study, and the will has only recently been found, so we're not going to have an issue with the time limit. We're not going to fall foul of section 4. Um, so um, we know that Andrew is within the category of person who can make an application. We know that he's in the time limit. What we want to know is what is reasonable financial provision. Now, you'll see from the next slide that there are actually two standards that apply. So there are two different standards depending on your relationship to the deceased person. So let's have a look at the surviving spouse standard first. Now, we know this isn't going to apply to Andrew. This would in fact apply to Tara. So it says there, such financial provision as it would be reasonable in all the circumstances for the husband or wife or civil partner to receive, whether or not that provision is required for his or her maintenance. So this is a very generous test. Um, and so, the wife, or the spouse, I should say, of a wealthy deceased person can expect to, to a degree, to enjoy a similar lifestyle to that which they have become accustomed. And it's very similar to what a spouse may get on divorce. So that's the surviving spouse standard. Now we know that's not going to apply to Andrew, so let's have a look at the next standard, which is the maintenance standard, which applies to all other applicants. So this is all other applicants. As it says there, you can see such financial provision as it would be reasonable in all the circumstances of the case for the applicant to receive for his or her maintenance. So here the court is primarily concerned with the basic living needs of the claimant. It's a much stricter test than that of the surviving spouse standard, although there is some latitude so that the court is not limited to just making sure that they have food and shelter. And as I said, this is the standard that would apply to Andrew. So what how when they're deciding what's reasonable, the court are going to look at certain guidelines before making an order. And we'll be looking at these shortly. Well, I'm going to be asking you to look at them and to apply them to our scenario. Now, I think we have those in a document which Legal Cheat can drop into the chat, or you may wish to take a photograph of this slide. So we'll just hang on to this slide for a couple of minutes, let you take a picture of this slide, because this is where you're going to do some work. This is what our students would do in the workshop. So either take a picture of the slide, or I think that Legal Cheek have posted the facts of the case study. I can see that in the chat now. So before we move on to that, we have to, when we were developing our materials, we had to ensure, as we had to absolutely ensure that they fitted within the SQE specification. So if we move on to the next slide, hopefully everybody will have got the guidelines in some format or other. These are the SQE specification as published by the SRA. And if we move on to the next slide, we've got the bit highlighted that we're very much focusing on today. We can see that this is a screenshot of the SRA specification, and we see that their syllabus includes claims against the estate under the Inheritance Provision for Family Independence Act. We've got to consider the time limit. Yes, we know that. We've got to consider the applicants, which we've covered, and the grounds is failure to make reasonable financial provision. So all our materials, not just on wills, but on all the modules that we teach, are carefully aligned to the SQE specification, which can be found on the Solicitors Regulation Authority website. So, as we know, we're focusing on this in our workshop. So let's have a look at where we are in our learning cycle. So, as we said, prepare and apply are what you do outside the classroom. And now that we've got enough preliminary knowledge from our prepare and apply stage, we're ready to start the workshop itself, which is called the collaborate stage. So, this is where we are at in the BPP learning cycle. And after the workshop, your knowledge is embedded with additional activities, including assessment level MCQs, and that's known as the consolidation phase. So that's a bit that you do outside the classroom once you finish. So prepare and apply outside the classroom before the workshop, collaboration in the workshop, discussing the case study, which we'll do shortly, and then consolidation, what you do afterwards, after the workshop, where you have assessment level MCQs to make sure that you have understood everything in that workshop. So that's what we've got to do. So we will have, we've got 3 multiple choice questions later. So we are going to do the consolidation stage. However, we're up to the collaborate stage. So let's have a look at what we would cover in this workshop. And as I say, we're just doing a small portion of it. So at the start of every session, and I imagine, that those of you that have done that are at university at the moment, you'll be familiar with the learning objectives. Hopefully, at the start of your classes, the tutors make it clear what the objective is for the session. Now, you'll see that we've got 5 on this slide. The first 3 are faded out because we haven't got time in this small session today to think about those, but as you can see, it talks about making a will, etc. What we're focusing on are 4 and 5. So understanding the statutory procedure to make a claim under the Act, and then what we're going to do in our mini workshop, I should say, to carry out a case and matter analysis relating to a potential claim under the Act. And case and matter analysis is part of the SQE2 assessment, but it's important that you cover it in SQE1 because it all goes down to this knowledge and understanding. You need to be able to have the knowledge, in this case of wills and the administration of estates, and understand it in order to apply to multiple choice questions, and also it feeds in to SQE2 as well. So let's have a look at the case and matter analysis. So I'll have a look at this grid that you can see on the screen now. So, in case and matter analysis, we'd say that you've got to identify the cause of action, the relevant law, and then apply the law to the facts and advise Tara, who's come in to see you because she's received that worrying letter from Andrew that we saw a few minutes ago. So, the cause of action is for Andrew to make an application under the Inheritance Act. We know that. We know that he's able to do that. Um, he's got to show, in order to bring a claim, he's got to show that he is one of the eligible categories of claimant and that reasonable financial provision has not been made for him. So we've covered that he is, as a child of the deceased, we know that Section 1 says that he is one of those persons in a category able to make a claim under this act, and his claim, or the basis of his claim, is that the will has not made reasonable financial provision for him. So um, we'll go back to the case study in a minute, but what I would like you to do, from having a look at the documents that have been posted, so using the study handout and the guidelines from the Act, I'd like you to consider in the next 5 minutes the strengths and weaknesses of Andrew's case. What do you think would influence the court in his favour? And I want you to think about whether you think his claim would be successful. Now, the beauty of this exercise is there's no right answers. Lots of right answers, I should say. There's no wrong answer. Lots of right answers. So I want you to have a think about um, what are the strengths and weaknesses for Andrew making a claim, and whether you think that what advice would you give to Tara in the situation. So I'm going to give you, I'm mindful of time, it's 16:36 on my computer, so I'm going to give you about 6 minutes, 5 minutes, let's say, to have a think about it, and then we're going to go through it together. So have a look at the information in the letter, have a think about what you would take into consideration, and I think we can move on to the next slide as well. Thank you. So this slide sets out under section 1 what the court takes into consideration when deciding whether or not to make an award to an applicant. So lots of stuff to think about. Yep, strong points for Andrew, absolutely. So what you would do if you were presenting this in court is you'd think about each of those points A to G, each of those different subsections A to G, and think, can I make an argument on behalf of Andrew? Can we make a point on behalf of Andrew to support his application for inheritance, for an award under this act? And even if you're advising Tara, and especially if you're advising Tara in any litigation, in any contested matter like this, you have to anticipate what the other side is thinking as well. So that's really important, that you think the reason that we're doing it from Andrew's point of view, even though ultimately we're going to be advising Tara, is that we need to work out what our opponent's case is, because we need to be able to counteract it. We need to work out the strengths of our opponent's case to decide our tactics. There is a question about mental health. Does mental health count? Under F, it does refer to any physical or mental disability of any applicant or beneficiary, so it can be relevant. We know that Andrew has said that he's finding it difficult to get a job following university. He's in low paid work, which may impact his mental health. Um, Lots of good stuff is coming in now from various people. Really good answers here. Andrea's mentioned undue influence. Um, we have pared down what we can cover in this session, and in the workshop we do talk about undue influence. You're absolutely right, Andrea. I hope I'm pronouncing that correctly. We do talk about undue influence, but we have had to sort of pare back things for this session. But yes, you're right, that would certainly be something that could be considered. um, yeah, so we've got lots of really good stuff that's coming in. Financial hardship, absolutely. Taking antidepressants, mental health issues. He's only received, I like this, he's only received 4% of his father of estate compared with the overall estate. And the cats home have received twice as much as he has. I think Fluffles and Co will be delighted, but again, that's a very strong argument for Andrew, isn't it? That the cat's home has received far more than he has. I really appreciate everybody who's contributing to this session today. And I hope you get an understanding that, were we in a physical classroom, there'd be lots of interaction, lots of discussing this application of the law to the facts. And by teaching the law in context, that gives you that in-depth knowledge and understanding of the law, how it all fits together. So this is, very realistic that we would expect in the classroom for students to come up with all these ideas that you're coming up with, which is really, really good. I like, one of the weaknesses it might not be able to afford ongoing legal advice. Um, did his father actually provide maintenance while he was still alive? Yeah, we can assume that there was nothing. They had a normal father-son relationship, so we're not aware of anything that would indicate that father and son had not got on. Um, so the amount that the cat shelter has received is just indicative of, I would say, the size of the estate and the distribution. So Andrew would say, somebody put 4%, and the cat's home received 8%. So it's sort of weighing everything up. It's weighing everything up. Yeah, the personal relationship is important. Um, there's loads of really good stuff that is coming in. Yeah, and because there are so many of you, as I say, normally we would have 20 in the workshop. Um, there's far more than that on the call, which is really excellent. And it's really good that you are engaged so much. So let's have a quick think about it. So the first one is A is the applicant's financial resources and needs. We know that Andrew has recently graduated and he's in low paid work and he's relying on his girlfriend for accommodation. The financial resources and needs of any other applicant. We're not aware of any other applicants, so that's probably not going to be applicable in our scenario. The financial resources and financial needs of any beneficiaries. So there, we don't know much about Tara's finances, but even taking her share of Robert's estate into account, we can see that she is well provided for. Any obligations and responsibilities which the deceased had towards any applicants of or beneficiaries. Well, as I've said, there's nothing to say that Robert and Andrew didn't have that normal father-son relationship because Andrew was staying with Robert and Tara while he was studying. So, as far as we know, there was nothing there. Taking in the size and nature of the net estate, it's a sizable estate. As we said, £500,000 with plenty of liquid assets. I think it's 185,000 in cash. Um, we've talked about the depression and the mental health. I would question whether it would actually qualify, but perhaps, we don't know the severity of it, and perhaps we could ask for medical evidence to support or naysay it. And then conduct, any other matter the court considers relevant in the circumstances, including the conduct of the applicant or any other person. So it's not going to be particularly relevant here. Now, the other thing I just wanted to highlight, if we move on to the next slide, is that we've talked about, these are the common guidelines that we've been looking at. When it comes to each category of people, there are individual guidelines, and we can see that under section 3, where the applicant is a child of the deceased, as Andrew is to Robert, the court must also consider the manner in which the applicant was or might be expected to be educated or trained. But we know from the fact pattern that actually Andrew has finished at university. So unless he wants to go on to postgraduate studies, he might decide to train to be a solicitor and want to do the SQE or the law conversion course. That's not going to be relevant in our scenario. So if we move on to our case and matter analysis, applying the laws to the facts. And as most of you put in the chat, which was really excellent to see, is that, you felt that, Andrew had a strong case. Andrew has limited means as against his father's substantial estate. So no particular reason why he shouldn't be provided for. And before we click on to the next bit, what would you advise Tara to do? So in this scenario, we think that Andrew's got a a strong case, which I think we're all agreed. What would we advise Tara to do? We think that Andrew's got a strong case, so what might we advise Tara to do? I'll give you a minute or so. Yeah, Tara should negotiate. Absolutely. Offer a settlement. Absolutely. Head it off before it goes to court. You're absolutely right. Mediation, absolutely. These are really excellent answers that are coming in. So you're absolutely right. What you would advise Tara to do, because we do actually act for Tara in our scenario, is that we would advise her to negotiate a settlement through mediation, through ADR, by whatever means possible. If we click on, we will see that, there is a strong risk of Andrew's claim succeeding. And if the court orders a large sum to be paid from Tara's estate, that is a real risk. So as you all identified, and, thank you very much for your contributions, we should, or Tara should attempt to settle. So that's one of the tasks that we would do within the workshop. As I said, we've taken a peek, we've extracted a task out of it. There's far more to do in the workshop. We look at Robert's will, etc., etc. But now that you've had an opportunity to apply the law in the collaborate phase, we're now ready to move on to the consolidation phase, which is the multiple choice questions. So we're going to have the options in the polls. So I think we're ready for, well, just before we move on to the multiple choice questions, when it comes to the SQE, we very much looked at, we've given our characters names, Robert and Tara and Andrew, etc. When it comes to the SQE, the SRA simply refer to people as a man or a woman. So they don't necessarily give the people names. So that's the characters' names in the fact pattern. So that's something to bear in mind. The other thing to bear in mind is that you get about 1 minute 40 seconds per question. Okay, so you get on average, 1 minute 40 seconds to answer each question. Some questions you'll answer very, very quickly, and others may take a bit longer. But if we can just go back to question one, thank you very much. So I'm very appreciative of the people, the team from Legal Cheek who are supporting me on this event. So it's brilliant. Thank you very much to them. We've got the first question, and this is question one. So hopefully we will get poll one up. So 1 minute 40. So I hope we're getting some votes in now, which is brilliant. I'll give you a few minutes. Well, 1 minute 40, I should give you. Okay, we're getting lots of votes in now. Just another couple of moments. Okay, I'm conscious of time, so let's feed back on that. So those of you that plumped for option A, that is the correct answer because the woman's partner could apply as a person maintained at the date of death. They can't apply as a cohabitee because they've not been living together for 2 years immediately preceding the death. And the stepchild could also apply as well. Um, they as somebody being maintained, and the woman's children can also apply. Just because they're adult and receive her estate under the intestacy rules, it doesn't preclude them from being able to issue a claim. but it doesn't necessarily mean they will get an award. And that's really important to remember. Just because you are somebody who is able to bring a claim doesn't mean that the court will decide in your favour. Okay, so well done, everybody who got A. Let's have a look at question 2 now. So hopefully you can all see the options for question A, question 2, I should say. Question 1. I can see the votes coming in. Question question 2. So Jay was in a long-term relationship with M and lived with him for 5 years until his death. They weren't married or in a civil partnership, and M's will left everything to his brother, and Jay feels that she has not been provided for. So those of you that have gone for option B is correct, because it is a person who's cohabited with the deceased as if they were spouses or civil partners for 2 years immediately prior to their death. So that is the correct answer. So well done, all of you who chose option B. And looking at the third and final of our multiple choice questions. So a man died 8 months ago, and the grant of probate was issued 4 months later. By the will, the man left all of his estate to his son and nothing to his partner, with whom he'd been living for the last 3 years. Is the man's partner wishes to bring a claim? Is the man's partner able to bring a claim? So he died 8 months ago, and the grant of probate was issued 4 months later. So we're focusing here on the time limits. So I can see that we've got various votes in. So we've got to remember what it says in section 4, and I'm mindful of time. I can see it's 16:59, and I can see that the vast majority of the votes, I know this is slightly trickier one, so the majority, not by that much, is for E, which is yes. And remember that section 4 says that an application cannot be made more than 6 months after the date of grant was made, although an application can be made before the grant was issued. And if we double check the fact pattern, it says that probate was issued 4 months ago. So is the man's partner able to bring a claim? The answer is yes, because probate was issued 4 months later, so we've got 6 months from the date of the grant of probate. So that's the final slide. We're just we would confirm that we have covered everything in our learning outcomes. So that is, as I said, an extract from what we teach under workshop 2. Now I believe that we now all move to the next stage. Juliet is going to come in and explain it all to us. Thank you very much, Juliet.
Fantastic. Thank you so much, Hilary. That was an absolutely brilliant introduction to SQE1. And thank you again to all the students that participated throughout that session. You really did make it really great. And it must be very different, Hilary, doing it virtually as opposed to in person. But yes, as mentioned at the beginning of the session, the event is not over yet. But before I direct you all to the networking, I just wanted to flag a couple of things. So if you have any other questions about the SQE and you want to learn about it in your own time, we have dozens of questions up on our SQE FAQs page with answers written by BPP's SQE experts, covering a wide range of different topics. So please do check that out if you want to learn some more about the SQE. So yes, we do have an hour of networking left over for you to ask all of your questions to Hilary and the BPP University Law School team. So Hilary, one more thank you to you. I can see that students are sending through their thank yous in the chat as well. For you to head over to the networking, if you just click on the Expo tab on the left-hand sidebar, that should take you into the Expo, and there should be one booth there for you to head into. So feel free to head over whenever you're ready. For those in the audience, click on Expo now to join Hilary in the left-hand sidebar. Once you're in the Expo, click on BPP's banner to enter the booth. We'd really recommend sharing your audio and video during the networking so that you can ask your questions directly to the BPP team. And then once your question's been answered, it'd be great if you could just come down off screen and then let others ask their questions, just to make sure that the session runs as smoothly as possible. Before I go, I also just wanted to flag that we're running an SQE2 taster session in just over 3 weeks' time, also in partnership with BPP. So if you'd like another session like this, exploring the second part of the SQE, please do sign up for that event on our website. But for now, I will let everyone go and see you over in the Expo.